Infringement File Sharing Amendment Bill, second reading.
You're seeking a call, Honourable Dr. Wayne Knapp.
Thank you, Mr. Speaker. I move that the Copyright Infringing File Sharing Amendment Bill now be read a second time. On behalf of the Minister, Mr. Power, I'd like to thank the Commerce Select Committee for its consideration of the bill and hearing over 200 submissions that have resulted in changes to the bill. Mr. Speaker, as members will know, and indeed those interested in the community on this issue, this bill has had a long genesis and has involved a complex debate on difficult issues. And at the heart of those issues was the impact of the internet on copyright law and the effect that that had on incentivising creators to produce original works. It is important in law that we provide appropriate protection for creative industries so that they can continue to provide jobs for New Zealanders and continue to contribute to our economy. But at the same time, of course, these same creative industries must adapt to changing technologies and the changing marketplace for creative works. Mr. Speaker, the Copyright Act 1994 grants exclusive rights to creators of original works so that they, in a sense, can make an economic return on their creative endeavours, and that provides a vibrant industry in the fields of music, literature, films and software in particular. So ensuring that copyright owners have effective measures to enforce their copyright is consistent with the government's key goal of encouraging economic growth. However, amendments had been made to the Copyright Act in 2008 which were intended to bring the 1994 Act in line with the contemporary digital landscape. And these amendments included Section 92A, and I do note that Claire Curran, the member for Dunedin South, has written extensively on this issue on her various blogs, which has required the Internet service providers, ISPs, to adopt and reasonably implement a policy for the termination of repeat copyright infringers. However, as the House will know, public and industry opinion was that Section 92A was in fact unworkable. And so accordingly, this government stopped that provision from coming into force and undertook to look at the issue again. So this bill repeals Section 92A of the Copyright Act 1994 and also amends Part 6 of the Act to provide a fair and balanced process to deal with online copyright infringements. Mr. Speaker, currently copyright owners lack an effective enforcement measure against illegal file sharing, somewhat practiced by many people who use the internet. Claims often of a younger age group. I would not do this. Claims in the district court for copyright infringement by file sharing would be too expensive. However, I might note that I do know younger relatives who may possibly have done this. That the file sharing would be too expensive and costly for both the copyright owners and for those wishing to contest infringement claims. The current process is unduly complicated in that the copyright owners need to apply for a court order to get an ISP to release an internet account holder's details before they can make a claim. So this bill provides for copyright owners or their representatives to send information showing alleged copyright infringement via file sharing to the relevant ISP. The ISP will then match that information to an account holder, and this is the important point, Mr. Speaker, may then send up to 3 infringement notices within the prescribed timeframes. This is known as the 3-notice rule. And if the account holder then ignores those warnings and continues infringing, the bill provides the copyright owner to take a claim to the Copyright Tribunal, and the Tribunal can make awards of up to $15,000. As other speakers will note, that there are other provisions there in that bill as well, including a provision for copyright owners to apply to the District Court, as opposed to the Copyright Tribunal, to suspend the suspension of an internet account for up to 6 months in appropriate circumstances. The key recommendation from the Commerce Committee is that provisions on the bill relating to internet suspension do not come into force until such time as specified by an order in Council. And I should note there are a large number of submissions on this specific issue arguing both for and against internet suspension as a deterrent for copyright infringement. So the compromise recommended by the committee and supported by the government is one that provides the right balance between the interests of internet users and the need for effective deterrent against illegal file sharing. Mr. Speaker, this government is committed to monitoring the infringement notice process and the Copyright Tribunal process to determine whether or not they are in fact a sufficient deterrent to illegal file sharing. Another key recommendation from the committee is that ISPs will not be initially required to set up a notice sending system for their mobile broadband networks, and this of course is an increasingly popular system for file sharing. This is a period for 2 years after the bill comes into force, whilst the government monitors any copyright infringing activity from these sources as those devices increase in their capability. However, an order in Council can change the date that these networks are included if there is a substantial increase in the volume of file sharing over the mobile broadband, and that would be an essential part of noting change in technology and change in internet capacity through broadband networks. Mr. Speaker, there were a number of submissions on whether or not there should be specific exceptions included in the bill to prevent an order or award being made by the Copyright Tribunal or the district account against an internet account holder. The government considers the committee has developed a sensible recommendation on this particular issue. They have recognised that creating specific exceptions in itself would create loopholes, and has instead recommended that the tribunal or the court has the discretion not to make an award or order where it would be manifestly unjust. This will allow the relevant body to determine on the facts of each case whether or not an award should be made in circumstances. It is important to note that internet users should attempt to ensure that their connections should not be used for illegal purposes. That's a very circumspectly provided such sentence. There may be a number of useful technical procedural amendments proposed by this committee which the government will support. And the government will be tabling an SOP in the committee stages which will propose minor technical amendments. The SOP will also amend the commencement date for the Act from 1 July 2011 to 1 September 2011. Mr. Speaker, in closing, I would like to reiterate the government's commitment to ensure that the Copyright Act remains a useful and effective tool for New Zealand's creative industries who contribute significantly and will increase in the future, as I know from my specific role as Minister of Science and Innovation, will contribute significantly to our economy, to our culture and to our role in the wider world. Mr. Speaker, I commend the bill to the House.
The question is that the motion be agreed to. Claire Curran.